To unpack this ruling for us, we're now joined by legal expert Mpumelelo Zikalala, and he joins us now via our video link. Mpumelelo, thank you so much for your time this evening here in SABC News. I mean, we all saw that judgment today, and maybe let's begin here. What do you make of that ruling? Were you at all surprised by it?
I would say I was a bit surprised, especially when it comes to urgency. I think the court then looked at it and said, there is irreparable harm which is going to be suffered, and there are no other alternative remedies that are there. We need to deal or stop Dr. Hlophe from sitting within the JSE so that they'll be able to adjudicate on that matter. But there are various implications of that decision. Firstly, then the next question is, how is the vacancy of Dr. Hlophe going to be filled in by Parliament? Is that vacancy going to be filled in time for the JSE interviews, which are yet to be held in October? If that is not able to be done in time, that means there are going to be provincial divisions and maybe the SCA, even the Constitutional Court, which is not going to have any interviews that can be conducted, and those vacancies are not going to be filled in. And yet, we know that vacancies are still there within our courts, and they need to be filled in as soon as possible. So it rests upon Parliament to then decide what is it that they can do. And if they decide to omit MK as a political party, then what criteria is going to be used by the Speaker in order to do that? The second part is the insinuation which has been stated by the court to say that whenever an appointment or recommendation is being made by a political party, the Speaker has a duty to then look into that appointment and think, is an appointment a rational one? Now, that places a bit of a burden on the Speaker, because what criteria is going to be utilized in order for the Speaker to determine whether the person that has been deployed in a certain committee does have the competencies to apply or to be in the particular committee without looking into the merits of allowing them an opportunity to provide reasons as to why they've deployed that particular individual. So I think the work of the Speaker is going to be quite a lot moving forward if we move on with what the court has told us today when it comes to the role that has to be done by the Speaker when it comes to deployments.
And maybe let's talk about, how complicated this matter is. I mean, we have an impeached judge who has been selected by his own party to be on the JSC Commission to select the appointment of new judges. What makes this very complicated? And like you're saying, that they're placing more responsibility on the Speaker.
I think that this one, there has to be a distinction between what Dr. Hlophe is going to do within the JSC and his role as a judge. So if the position was that he needs to go back and be appointed as a judge was one of the candidates, I think maybe the decision could be more concrete to say, but you've been impeached, you can't come back here. But if you take a step back and you say, his role has now changed, he's going there to be an individual that will be able to select whether a person can be appointed as a judge. Now, one of the things which are looked at, yes, it is the integrity and fit and proper person being there. But one of the important things is the competencies of the individuals, their qualification, their ability to adjudicate matters, whether they've done or presided over civil and criminal matters and all of those things. Now, if we look at it on one side, one person could argue and say, here's a perfect person that will be able to do that, who has been a judge president before, knows the weight and the amount of work that goes in being a judge. So if you include him as part of the individuals who are going to assess whether the person is fit enough to be a judge, then it's correct. However, you have the second side or the second leg that says, well, if you are found to be, you have misbehaved as a judge, how then do you have the integrity, or how then can you be able to trust that the decisions in which you are going to take for all future judges is going to be the one which is correct? So I think that's what the second part or part B of the application is going to concentrate on. But most importantly, is going to be on the Speaker, because you are now allocating powers to the Speaker, which I would generally think those powers are not there, or they are not explicit when it comes to the Constitution. The Speaker does not have a role in determining which person is deployed where. It is the political parties that have decided that, due to the fact that it's members of the public that have voted, and they've said political party A, B, and C, and D go and represent us in Parliament. How you represent us, it is completely up to you. Just as long as the person who is in Parliament is eligible to be there, they must be able to execute all the duties that are there. Because if we allow this particular process now, the next one which is going to follow, we are then going to come back and say to the president, whenever you've chosen someone to be a minister or the deputy minister, we want to know the reasons why. Are there any qualifications that are there that you've looked at? Are there any attributes and maybe the strides and the contributions that the person have made? If rationality is not there, you may find certain individuals going to court and saying that your decision, it may be lawful, but when it comes to rationality, is a bit of a problem. You may have followed the particular procedure which needs to be followed as per the law, but you haven't showed us the reason or the motive of why you are deploying that particular individual to that committee or to be that minister or deputy minister.
And what happens now if Dr. John Hlophe should appeal this ruling? And of course, we do know that the interviewing process for new judges is expected to take place next month. And ironically, of course, they are also looking for a Western Cape president to head that court. And that's a position that Dr. John Hlophe also held.
Now, remember that what was issued today was an interim ruling or an interdict that says you can't sit within that particular committee. So the next alternative that could be there, MK could say, we're now submitting another name of another individual that is going to sit there so that we allow the interview to continue and take place during the stated time, which is in October. There is a second option in which Judge Hlophe, Dr. Hlophe can then come back and say, no, I want to take an appeal, to take this matter on appeal on the interim ruling. Let alone that the second part of the matter has not been heard, but I want to deal with how the court looked at the agency, for example, when it comes to issues like alternative remedies, when it comes to issues of irreparable harm, the reasoning when it comes to basing it on what the speaker is supposed to do and the lack of the speaker in order to take their position and to take a decision whether it is a rational one or not. Ordinarily, you wouldn't find many litigants taking an interim ruling on appeal, but it is something that can be done if you are going to motivate on it to say this is why you want this particular process to begin. But it may also have the potential of stalling or maybe causing the interviews which are meant to be held in October to be postponed if Parliament is not going to act fast enough to find a replacement. If there's a missing quorum within the JSC, then the JSC cannot continue if it's not constituted properly.
And, talking about this matter as well, taking this case to the Constitutional Court, how important would it be for our country for this matter to be heard finally by the Constitutional Court?
It would be important, especially when it comes to defining the role of the Speaker when it comes to certain deployments. Where does it start and where does it end? Where does the independence of all the political parties that are there comes in? What then do you look at? Because it seems as if, from where it was stated today, it's almost as if once a nomination has been made, it's an application. The Speaker still needs to apply their mind before that particular nomination is been okay. If that's the case, then the next question is, Speaker, what is the criteria and methodology in which you are utilizing? Is that particular methodology in line with the will of the people and what the people are looking for? What is it that you look at? That must be explicit from the start to prevent instances and situations in which members of Parliament are going to be nominated, and it's the Speaker that's going to say no. And then the next question would be, what is the basis of you saying no, Speaker? If that particular basis is not rational, then it stands to be set aside. So for Parliament, this judgment for me goes to the crux or goes to the core of what they're doing the most. And I think it's something that they must start to look at to say, how are we going to deal with these procedures moving forward? And then secondly, the implications on the JSE. Would it be properly constituted before the interviews? If the answer is no, what's the implication when it comes to all the vacancies which are there within the various courts?
All right, Mr. Zikalala, thank you so much for your time and for that insight. That's Mpumelelo Zikalala, legal analyst there, just giving us his insight in terms of that court order we saw coming out from the Western Cape High Court today.